Hello, I'm Calvin Curtis. It's a pleasure to be with you. For the next 40 minutes or so, we're going to talk about the interplay between family law issues, elder law issues, and issues germane to special needs planning. As you listen to this presentation, you'll want to hit the link and find our article, The Interplay Among Family Law, Elder Law, and Special Needs Planning, because we'll be using it throughout this presentation. So who are we talking about today specifically? I think we're talking about 3 or 4 groups of people. First off, we're talking about adult spouses who are disabled under the age of 65. Second, I think we're talking about adult children who are disabled, but who may still be receiving child support. And third, I think we're talking about individuals who perhaps have married late in life and foresee the possibility of a divorce because one of the spouses may need extensive long-term care, or we're talking about situations in which one spouse, perhaps under age 65, has suffered a catastrophic medical event that the other spouse simply is not able to accommodate. To understand what we're talking about here today, we first have to lay some groundwork. There are a couple of important principles that you have to understand. First off, we've got to talk about government benefits. And for our purposes here today, that consists of Social Security disability income. These are individuals who have been determined to be disabled by the Social Security Administration. They've had a hearing, they've had an appeal if need be, and they've been determined to be disabled, and they are receiving Social Security disability benefits, SSDI, attributable to their disability, and in most circumstances, attendant to their own work history. When an individual has been disabled for 2 years or more, they can also receive Medicare benefits. So this is the exception in the Medicare world to an individual having to be over age 65 to receive Medicare benefits. Again, if an individual has been disabled for 2 years or more, they can receive Medicare assistance. Now, these 2 benefits are important, but they're not going to be the focus of our presentation today in large part. And why is that? The reason for that is these are entitlements. They are premised upon an individual's work history, paying into the system. They're not means tested. If Bill Gates from Microsoft were determined to be disabled, despite his billions of dollars, he would be entitled to receive Social Security disability income and Medicare assistance. Now, on the other hand, we need to talk about Supplemental Security Income, or SSI, and Medicaid. Supplemental Security Income is a program designed to provide a nominal amount of benefits, give or take $700 a month, to an individual who is disabled and financially impoverished, meaning assets of less than $2,000 and no income or very little income, either earned or unearned. SSI, because of the asset limitation, often goes hand in glove with Medicaid eligibility. But Medicaid eligibility can be important in its own right. Medicaid eligibility is particularly important because it's not health insurance. Rather, Medicaid is full payment of eligible medical expenses. So, Supplemental Security Income, SSI, an individual is disabled, they have assets of less than $2,000, and they may also be eligible for Medicaid. Now, once we understand government benefits, we also have to understand special needs trusts. And there's 2 primary types of special needs trusts. The first type that I want to refer to is known as a first-party special needs trust. Why do we call it a first-party special needs trust? Because the assets at issue belong to the individual. The assets belong to the individual. A first-party special needs trust is irrevocable. It pertains to an individual who is disabled. This individual is also under the age of 65. That's a requirement. This trust is has to be created by a parent, grandparent, guardian, or court. The individual cannot set up this trust by themselves. Rather, they have to have the court create the trust, or they have to have a parent sign off on the creation of the trust. The parent won't be involved with the trust, but it's a statutory requirement that the trust be created by a parent, grandparent, guardian, or court. Next issue, the funds in the trust have to be utilized for the sole benefit of the disabled beneficiary. The sole benefit of the disabled beneficiary. Perhaps the easiest way to understand the sole benefit rule is to think of a family trip to Disneyland. If an individual with disabilities, a beneficiary under a first-party special needs trust, wants to take a trip to Disneyland, according to Social Security, the expenses attendant to that individual, such as their airfare, their lodging, their admission tickets to the theme park, can be paid for by the trust. The expenses of one indispensable care provider can also be paid by the trust. However, the trust cannot pay for the airline tickets or theme park admission of other family members, siblings, or what have you, because the funds at issue have to be for the sole benefit of the disabled individual. Now, if this family trip occurs in a car, then the fuel for the car can be paid for by the trust because the beneficiary is in the car. And if the entire family stays in the same room at a hotel or what have you, then the trust can pay for that lodging as well. But trust cannot pay for airline tickets or theme park admission for collateral family members other than that one indispensable family member who attends. A first-party special needs trust, as I mentioned, also contains the assets of an individual. So oftentimes, some of the folks who set up the most first-party special needs trusts are actually personal injury lawyers or trial lawyers. We hope they'll come to us to have them help with that. But the idea is that their personal injury victim is entitled to recover a personal injury award attendant to their own physical injuries. And if they're disabled and under age 65, and we're trying to retain Medicaid eligibility, we're trying to retain supplemental security income benefits, then a first-party special needs trust may be in order because the assets belong to the injured individual. Now, finally, there's one serious drawback to a first-party special needs trust, and that is this so-called idea of a payback. The idea being that upon the death of the beneficiary, Medicaid is entitled to recover the value of services provided before the funds in the trust can go anywhere else. Let me restate that. Upon the death of the disabled beneficiary, Medicaid is entitled to recover the value of Medicaid services provided to that beneficiary before the funds remaining in the trust can go anywhere else. Okay, that's a first-party special needs trust. Already you may begin to see its applicability in family law. Now, there's also something known as a third-party special needs trust. And the distinction is this. In a third-party special needs trust, the assets belong to someone else, like a parent or a grandparent. When I work with clients, I try to help them understand this issue by use of a very simple and silly example. You all know that if you have children, you don't have to leave your children anything. Individuals get disinherited with some degree of regularity, and sometimes those disinheritance situations make national news. You also know, since you have your own parents, whether living or dead, that you don't have any right to require anything from them. You can't go to your parents and demand any kind of an inheritance. So, if we take those two concepts, you don't have the right to inherit anything, you don't have the right to demand anything, and we apply it, if your parents or if you as a parent choose to condition what you leave someone, they have to live with those conditions. Let me tell you what I mean. Suppose if I have 3 children, one of whom is disabled, that I draft a will or a trust that says, divide my estate equally among my 3 children. And with respect to child number 1, I want an outright distribution of 1/3 to them. With respect to child 2, I want an outright distribution of 1/3 to them. However, with respect to child number 3, I want their share placed in a continuing trust. And the terms of that trust might say something like, the trustee may apply income and principal for the benefit of the beneficiary as the trustee sees fit in his or her discretion. In other words, they don't have to distribute anything, but we're going to educate that trustee as to how we want child number 3 taken care of. Now, in that setting, if child number 3 is unhappy, what if they went to court and said, gee, Your Honor, my child number or my sibling, older brother, older sister got their distribution outright. My second sibling got their distribution outright, but I've not received my share. I want my share. I think a judge looks at that, and I think a judge says, it appears to me that there were reasons why your parents set this up this way, and it's not my province to rewrite the will or the trust. You have to live with those conditions. They did it for a reason. They are entitled to do that. They didn't have to leave you anything. Now, so far this all sounds negative, but in the world of supplemental security income and Medicaid, it's essential, and here's why. If the child doesn't have the right to demand anything, then SSI and Medicaid cannot attribute anything to them. In other words, if the child doesn't have an absolute right to take possession of $100,000 or whatever amount is in the trust, Medicaid and SSI can attribute that amount to the child. So the child can have all of the benefits attendant to what those funds may provide, special needs, supplemental needs, what have you, without having those assets being counted toward their asset limitation, again, generally $2,000. Okay, first-party special needs trusts, third-party special needs trusts. What's a trust, after all? Let's be clear. A trust is simply a contract among 3 groups of people. First off, someone sets up the trust. That person is known as a grantor, a trustor, sometimes known as a trust maker. A trust is administered by a trustee for the benefit of a beneficiary. So if I set up a revocable trust for myself, for example, I may be the grantor, the trustee, and the beneficiary. But upon my death, someone else becomes the trustee, a successor trustee, and upon my death, my children or someone else becomes a beneficiary of the trust. Now let's turn to consideration number 1. And who we're talking about here is an individual under age 65 who is disabled and is divorcing. Now this individual may have limited resources or income. Medicaid may already be an issue, or there is some sense that Medicaid eligibility may be becoming an issue in the future. Can a first-party special needs trust be used to receive an equitable distribution or a property settlement? Answer, yes. I want you to flip to your materials now, if you would, and let's look at example number 1. So in example number 1, as part of a divorce decree, a court awards a disabled spouse under age 65 an equitable distribution of $70,000. Since the disabled individual has assets in excess of $2,000, he or she is otherwise not eligible for Medicaid assistance. But if the funds are contributed to a first-party special needs trust, however, they're excluded from consideration in determining the individual's assets. Note, of course, that Social Security benefits are not typically the source of something that can be divided in a marital property situation. Okay, now let me back up and make sure we're crystal clear here. And let me go back to the personal injury analogy. We talked about an individual who's injured in a personal injury matter, how they can use a first-party special needs trust to fund or to house their settlement and retain Medicaid and SSI eligibility. Obviously, the issue here is the same. Whether the individual receives a property distribution, equitable distribution, property settlement, whether they inherit money, the issue would be the same. However, while instead of thinking of this after the marriage and saying, or after the dissolution of the marriage, and saying, well, just deal with it later on, realize that there can be some important financial and psychological reasons to consider it now and include it now. First off, by addressing the issue and getting it resolved, both parties have the peace of mind or the assurance that the issue is going to be addressed. Secondly, since our first-party special needs trust may need to be created by a court, if we're already in court, then it can be part of our divorce decree, and therefore we tick off that requirement without requiring a separate proceeding. So think about it sooner rather than later. Now, we talked about using a first-party special needs trust. Could we use a third-party special needs trust? Well, not typically. Why? Because what we're talking about here, a property settlement, well, it belongs to the spouse who's receiving it. It doesn't belong to someone else. And remember our distinction between first-party and third-party special needs trusts. However, I suppose it would be possible to do the following. Suppose a couple is divorcing. Suppose the couple says absolutely nothing about a property settlement in their divorce decree. Suppose that instead there is an understanding that one spouse will create a third-party special needs trust for the other spouse post-divorce. Could that be done? Yeah, I think it could be done. Again, nothing's going to be in the decree, so it's a trust situation, which might be a bit nebulous when parties are divorcing, but some lawyers use that concept in various situations for various reasons. So it may be worthy of consideration. Okay, now, if a first-party special needs trust can hold a property settlement, what about alimony? Can a first-party special needs trust receive alimony? Yes, it can. Flip to our footnote in our materials, footnote number 2. The Social Security POMs, their own regulations, if you will. A legally assignable payment that is assigned to a trust can be disregarded. For example, child support, which we'll talk about in a minute, or alimony payments paid directly to a trustee as a result of a court order are not income. So, in the appropriate situation, spouse under age 65, disabled, who is divorcing, perhaps receiving supplemental security income, but more likely receiving Medicaid, for example, we can take that alimony payment and have it made directly, irrevocable court assignment to a first-party special needs trust. Now, why would we do that? Well, we would do it because this individual may be having issues about the amount of earned or unearned income they may have for SSI purposes, but they may also be having issues about their income for Medicaid purposes. Community Medicaid sometimes requires a spend down for individuals who have certain higher levels of income. The idea being that as your income increases, there ought to be more money available to apply toward your medical expenses. So Medicaid will sometimes require a spend down. So if the alimony goes to the first-party special needs trust, as opposed to going to the spouse directly, we may avoid or minimize that Medicaid spend down requirement. That can be huge to the individual who's entitled to these benefits. Now, by the way, who's going to be the trustee of these various trusts? It's pretty important, isn't it? Can the divorced spouse be the trustee of their own trust? No. impermissible conflict of interest. I doubt they would understand the rules and requirements to the extent necessary, and they'd simply have too many powers as a trustee to apply the income for their benefit, likely resulting in SSI and Medicaid attributing the funds. So we're going to have a third party. That can be an adult child, for example. It can be a parent. It can even be the divorced spouse in some situations, but never the beneficiary. Okay, so this individual under age 65 who is disabled might want to consider use of a first-party special needs trust to house a property settlement and to house alimony, because they need to continue to qualify for Medicaid and they want to avoid a spend down. Now let's turn to consideration number 2, which I really consider the reason for this presentation today. On occasion, I will have a spouse come to me and explain the following to me. They have a profoundly disabled adult child. This adult child might otherwise qualify for supplemental security income. However, Social Security Administration is telling them they do not qualify because of the child support, which reduces SSI on a dollar-for-dollar basis. So there's a government benefit here that this profoundly disabled child might qualify for, but child support is precluding it. In addition, the child support may play in to the Medicaid spend down that we've discussed. All right, so what, if anything, can be done in this situation? Does child support affect supplemental security income? It absolutely does, yes. Let's look at the reasons why. If a disabled adult child resides with a parent and receives food and shelter, their SSI payment, typically around $700 a month, may be reduced by 1/3, attributable to the food and shelter. It's called, food and shelter is called in-kind support and maintenance, by the way, but the concept that I'm talking about is called the presumed maximum value rule, or the value of the 1/3 reduction. Social Security saying, look, an individual doesn't need their entire SSI payment if they're receiving food and shelter from a parent. So let's reduce that benefit by 1/3 because they're receiving food and shelter, which after all is one of the primary purposes behind SSI. So in this setting then, if child support is paid on top of this 1/3 reduction, you can readily see how on a dollar-for-dollar basis this disabled adult child would be receiving no SSI. On the other hand, if a profoundly disabled adult child resides with parents who are married, they may have the value of the 1/3 reduction, or the presumed maximum value rule. The benefit may be reduced by 1/3 because their disabled child has food and shelter provided. But there wouldn't be the penalty, if you will, of child support. So one way of trying to resolve this inequity is again through use of a qualifying first-party special needs trust. Again, adult child under age 65 who is disabled. The child support can then be irrevocably assigned and paid pursuant to a court order to a qualifying special needs trust that oftentimes then will negate this issue and enable the child to receive their full SSI benefit. This issue is going to apply to a number of your clients. It's going to apply in any setting in which they have a disabled adult child who may be continuing, perhaps because of the disability or perhaps because of the sense or the feelings of the divorcing parent, that child support remains appropriate. So the use of a first-party special needs trust can be a valuable way of resolving that issue. Now, can we use a third-party special needs trust in this situation? I think the answer to that is no. Again, remember that the child support belongs to the disabled adult child. Remember our distinction again. First-party special needs trust is used when the asset belongs to the individual. Moreover, we would anticipate that this child support is going to be used on a regular basis. So we're not thinking that we're going to accumulate a significant amount that would trigger application of the payback clause. So one of the primary reasons why we'd be uptight about use of a first-party special needs trust, the possible requirement of a payback to the state Medicaid office, can be ameliorated by the fact that the child support's likely to be used up during life. That leaves us now with consideration number 3. And this is really the age-old question of divorce in a situation in which long-term care may be required. So let me flip you to our outline and let's look at examples 4 and 5. In example number 4, John and Jane marry late in life while they're both in their 80s. This may be a second or a third marriage for each of them, maybe even a fourth marriage. Suppose John has $30,000 in assets and Jane has $500,000 in assets. They do have a prenuptial agreement. After living together for several years, John and Jane are no longer able to care for one another, and they no longer even reside together. Rather, John lives with one of his children and Jane resides with her daughter. When it becomes clear that John will need long-term custodial nursing home care, John and Jane decide to divorce. All right, let me pause here. Suppose that John and Jane have gotten together late in life. He has a family. He has children and grandchildren. She has a family, children and grandchildren. They love each other. They enjoy one another's company. They're of the same age, and they have affection and love and respect for one another. But if one of them ends up needing long-term care, that may be more than the other spouse has bargained for in terms of providing care at home or otherwise. And moreover, many people consider this to be a potential significant drain on a person's assets, and understandably so. Remember that we talked about in the world of Medicaid, the assets of a husband and wife are aggregated. Doesn't matter whether it's a first marriage or a fourth marriage. Doesn't matter whether there's a prenup or a post-nup or any other kind of nup. Doesn't even matter if they're living together. If they're married, they're married. And in this setting, Jane may feel that her entire $500,000 is at risk of being depleted in paying for John's long-term care. That may be more than she signed on for, maybe more than she is willing to do. Oftentimes, John's family will be facing similar issues, but sort of the reverse. They may be actively seeking to get Medicaid assistance for John, but now they find that Jane has assets, Jane doesn't want to talk about them, and they're precluding them from completing a Medicaid application and determining whether or not they can qualify for assistance. So in that setting, John and Jane may decide to divorce. Now, Medicaid says if a couple's married, they're married. But Medicaid also says that if a couple's divorced, they're divorced. And Medicaid isn't going to be looking behind the divorce for the public policy reasons or any other consideration. It doesn't matter why they choose to divorce. And from a Medicaid standpoint, that shouldn't even be a factor or a consideration. That issue simply doesn't matter. If they're married, they're married. If they're divorced, they're divorced, whatever the reason may be for the divorce. All right, the next situation, really our last situation, example number 5. Robert and Rosalie, both in their 50s, have been married for 30 years. Robert suffers a major stroke and is expected to need long-term nursing home care for the remainder of his life. There's considerable uncertainty over the length of time he may live. In evaluating their situation, Rosalie believes there's little she can do for Robert and frankly wishes to move on with her own life. Robert and Rosalie decide to divorce and want to consider use of a special needs trust to hold Robert's assets and assist in obtaining Medicaid eligibility. So, one spouse has the catastrophic medical event. The other spouse is feeling hemmed in. not what they signed up for. They're still young, in their 50s, late 40s, what have you. They've got a lot of life to live. And oftentimes they will say something like, you know what, the marriage wasn't all that great anyway. They may be considering a divorce, but that may be a situation in which we can use a first-party special needs trust, just like we discussed back in example number 1, and it can be of significant benefit to them. We've now completed our presentation. Thank you. We hope that you've found it helpful. We understand that you may have questions. These issues are complex. We would encourage you to give us a call and come in for a consultation. At a minimum, we can help you understand how these rules will apply in your situation. They're technical rules. We may be able to help you obtain some significant additional benefits. Give us a call. We look forward to helping you. Thank you.